Good afternoon. I'd like to call the Finance, Ways and Means Committee to order for April 9th, 2024. Mr. Clerk, would you please call the roll?
Representatives Barrett, Boyd, Camper, Cochran, Crawford, Faison, Freeman, Gant, Garrett, Hawk, Hicks of Hawkins, Hicks of Washington, Kiesling, Lamberth, Love, Lynn, McKenzie, Miller, Moon, Parkinson, Shaw, Sparks, Whitson, Williams, Zachary, Vice Chairman Baum, Chair Lady Hazelwood. Madam Chair, you have a quorum.
Thank you, Mr. Clerk. Do we have any personal orders or announcements before we get underway? Chairman Zachary, you're recognized.
Thank you, Madam Chair. Members, I have some special guests with me today. Madam Chair, just so you know, they said this was their second favorite committee to watch, but I told them that you're my favorite chairman. And so if you guys could make my parents feel welcome, Richard and Pam Zachary, if they give away. Thank you.
We are very glad to have you here today, and I don't talk nearly as fast as your son does in calendar and rules, but we get it done. Seeing no other personal orders or announcements, we have 15 bills on our calendar today, and we will get underway with item number 1, House Bill 1988 by Deputy Speaker Johnson. We have a motion and a second. Deputy Speaker, you are recognized.
Thank you, Madam Chair. House Bill 1988 renews the nursing home bed assessment through June the 30th of 2025.
I'm sorry, Deputy Speaker, I missed your explanation.
This bill renews the nursing home bed assessment through June the 30th, 2025.
We do have a question on the bill, and the only comment I would make is this bill is critically important to the nursing homes. It's critically important to the elderly citizens of Tennessee and their families. So thank you, Deputy Speaker, for bringing this bill. Without objection, we are voting on House Bill 1988. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it, and House Bill 1988 moves on to Chairman Zachary's Calendar and Rules Committee. Item number 2 on our calendar.
Madam Chair, Committee.
Item number 2, House Bill 2368 by Chairman Carr. You have a motion and a second.
Thank you, Madam Chair.
And I believe we have an untimely filed amendment on this bill by Chairman Williams. I think the sponsor has deemed it a friendly amendment. So without objection, we will consider this amendment.
Second.
We have a motion and a second. Chairman Williams, would you please explain your amendment to the committee?
Thank you, Chairman. Members, drafting code 018099. Chairman Carr and I had at length discussion about this bill. I completely understand the premise behind the bill. My concern, which this amendment speaks to, is if a local government decides to use this process in order to invest in the infrastructure to make sure that development moves forward, so they don't, in the instance that they don't have cash, this would allow an assessment on those properties in which those improvements were allowed to serve. My concern, as I shared with Chairman Carr, is that because we're having to find resources through the issuance of a bond, if the local government had an event which prohibited them from being able to pay the principal and interest amounts of the bond during the period of time in which the bond issuance occurred, that assessment on that real estate property could be reissued every time the bonds were issued. Therefore, that assessment could carry on in perpetuity. All this bill says is that, or all this amendment says is that for the purposes of these infrastructure easement funding vehicles, that it could only issue it for one bond, which couldn't exceed more than 30 years, so that the taxpayer and the person who assessed the easement or the property taxes on that property would eventually get relief from that original agreement sometime in the future when those bonds are paid off. That's all the amendment does.
You've heard the sponsor's explanation of the amendment. Are there any questions? Seeing none, we are voting on amendment drafting code 018099. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it, and the amendment 18099 is hereby attached to House Bill 2368. Chairman Carr, would you explain your bill as we just amended it, please?
Thank you, Madam Chair. Yes, this is the RETA bill. It's the residential act that as Chairman Williams just explained, it's going to allow for a developer to go in and put in the infrastructure to his development and to make it more affordable and for more houses to be built. And if an entity like the Industrial Development Board wants to bond that, they can bond that and pay him back all his infrastructure costs. That way he can start with the process a lot quicker of building those houses and making them more affordable. And we also had another amendment, but I just wanted to clarify that. The other amendment ensures that these districts only apply to property owners opting into the process. And it also allows for the auditor to have the audits as he wanted. And with that, I stand for questions.
And Chairman Carr, that amendment was traveling with the bill.
Yes, ma'am.
So, are there questions for the sponsor? Chairman Crawford.
Just one simple question. Chairman Carr, is this your last bill?
No, sir, I have one more.
And where is it at right now?
Right behind this, if Madam Chair wants it to be.
Good luck.
Thank you.
All right, without objection, we are voting on House Bill 2368 as amended. All in favor, please signify by saying aye. Any opposed? The ayes have it, and House Bill 2368 moves on to calendar and rules. Next item on our agenda is item number 3, House Bill 2623 by Chairman Carr, which I believe might be the chairman's last bill based on the last conversation that we just had. So,
Yes,
Chairman
ma'am.
Carr, you have a motion and a second, and you are recognized.
Thank you, Madam Chair. This is a bill that will help us even more with our housing, and this did come down from the Madam Chair's district. What this would allow you to do, if you're a developer and you want to go in and you want to develop some housing, and say, for example, that it was going to work, but it may not work, but this gives the Planning Commission the opportunity with the developer to maybe ease the restrictions a little bit on their guidelines, maybe not have as far as the setback or reducing the parking spaces, not just to make it more available for these people to make these apartment complexes and stuff, but it can only be no more than 5 units at a time. And with that, I stand for questions.
Are there questions of the sponsor? Well, as Chairman said, this did come from my county,
Yes.
and we have an affordable housing issue. I know that is a common problem across the state, and this is one way that we can begin to address that. So thank you for bringing the bill. Are there questions of the sponsor? Mr. Sponsor, Mr. Chairman.
Thank you. I just wanted to say that the one reason I took this is going to fit great in Sevier County also. It's just not for one county. This is statewide. And if you look at the bill and you get your planning commissions to do this, and I'll hush up. Thank you.
You're absolutely right. It originated in Hamilton County, but the impact can be felt everywhere if people choose to use this vehicle that we're in the process of approving. So without objection, we are voting on House Bill 2623. All in favor, please signify by saying aye. Any opposed? 2623 moves on to calendar and rules. Chairman Carr, you recognize.
Thank you. Is there any way I can avoid Chairman Zachary's committee or anything? I withdraw the question.
Well, Chairman, you could take it off notice, I guess. Chairman Zachary.
Madam Chair, sponsor, we can certainly send that bill somewhere else so it does not come through calendar and rules without question. Thank you.
Thanks, Steve. Thank you. Appreciate it. Thank you all so much.
Next on our calendar is House Bill 2686 by Chairman Doggett. You have a motion and a second. Chairman Doggett, you're recognized. And we have also have an untimely filed amendment on this bill by Leader Lambert. And Leader Lambert.
Sorry, Madam Chairman, I thought it was timely filed, but are we on amendment code 018138?
We are, but I'm sorry, it missed the deadline, sir. So it was untimely filed, but
I would move for consideration, please.
without objection, we are considering amendment code 018138. And Leader Lambert, as the sponsor of this amendment, please explain to us what it does.
Yes, Madam Chairman, this deals with diversion and expungement, and for years we have really struggled with this issue in the law to make sure that you only have one opportunity. So expungement was set up, and so was diversion, so that if you have someone who is a youthful offender, someone who's 25 years old and makes a mistake on something, that they could then get that expunged off their record. And it's supposed to be kind of a one-time shot. It's not supposed to be for career offenders that just keep breaking the law over and over again. This just clarifies that if you get a diversion that results in an expungement, or if you get an expungement, you get one shot at that. So you can get an expungement once, but you can't keep coming back to the well over and over again.
You've heard the sponsor's explanation. Are there questions? Seeing none, we are voting on Amendment 018138. All in favor, please signify by saying aye. Any opposed? The ayes have it. The amendment is attached. Chairman Doggett, if you would now explain what your bill does as amended.
Thank you, ma'am, and members of the committee. With that new amendment that just went on, as the leader had said, it specifies about diversion. The original bill, and even as amended, continues the same thought that we have, is that you are eligible to get expunction under one time, and it's going to be under G, K, or M in the current code.
Questions of the sponsor? Chairman Williams.
Thank you. Obviously, I don't serve on the committee. This bill came through, and the leader's amendment just made me think of a quick question. So is it expungement for one single offense, or if I committed 3 offenses, all 3 of those were expungible at that one time? Or is it just one offense, one time?
Chairman Doggett.
It's one offense at one time. Now, if all 3 of those offenses occurred in the same event, then yes, you would be able to get them. That would count as one.
Okay, thank you.
Other questions? Representative Love, you're recognized.
Thank you, Madam Chair. And I think along the same lines of the question that was just asked. So if you have more than one offense, one time expungement on that one offense, the other 2 are still non-expunged, can you ever go back and get those expunged?
Chairman Doggett.
Tell me if I'm asking the question that you're asking here. Is that in reference to what Representative Williams said, there was 3 offenses that occurred during one single act or an event, and you were able to get expunction for one, but not for the other 2? Is that what you're asking? If you could go back and get those other 2 at a later date, or?
No, I'm asking if you had different offenses on different times. So you have maybe 1 or 2 offenses on your record, and both of them are eligible for expunction. You get one expunged. Is it possible to go back and get another expunged at a later date, or is it just you get one time to get an offense expunged? I hope I'm not confusing the question.
Chairman Doggett.
I think I'm picking up what you're putting down there. When the expulsion laws were changed a couple years ago, I think the intent was you get one bite at the apple for the expungement. There was some confusion under that because of those 3 sections, G, K, and M, that is currently in the code. In some places, it was being interpreted maybe as the way you're presenting it, that you were eligible to get expungement here and not here, but you could come back and get it. What we're just doing now is clarifying that you get one time that you get to go for.
Right. Thank you, sponsor. Thank you, Chair.
Representative Shaw.
Thank you, Madam Chair. I think you cleared up what I was going to ask, because and thank you for the bill, because that's kind of been the problem, depending on what county you live in, where you live. They tell you one thing for expungement here and something totally different here. But are you saying that your legislation is basically going to clear all that up, and now you just get a one bite at the apple, one-time expungement, and that's it, and it's all going to be clarified the same wherever you are in the state?
I will say that our hope is to patch an issue that we have found that has existed for the last couple of years, and hopefully maybe the future General Assembly going forward can come back and revisit and make this as clear as day so it is completely unequivocally understood in all 95 counties that this is what the intent is, and this is how the operation is supposed to be conducted to get that expunction.
Thank you,
Representative Shaw?
Madam Chair. Thank you.
Leader Camper.
Thank you, Madam Chair. All right, Chairman Faison, calm down. Question, Representative Doggett, did we change anything in the legislation with respect to the time frame a person have to be, could go back for an expunction period? Did the time frame change at all around that, or, oh, go ahead.
I don't think that we
Okay.
made any changes. It's still, there's the 10-year period and there's a 5-year period that I think is what is currently in code. Again, the main thing we wanted to make sure was that it was as clear as it could be that you had one under those 3 different
I got it.
sections.
Thank you.
Representative Miller.
Thank you, Madam Chair Lady. The untimely amendment that actually made the bill, I'm trying to get an understanding, any offenders, is this to be somewhat of a preventive measure when you're actually, assuming it passes, all of that? Is it something that you go to the offenders and say, hey, look, this is a one-shot deal. You need to understand that, because if you come back with a second one, it's not going to happen for you. So is this somewhat of a preventive kind of approach?
Chairman Doggett.
I think it could be interpreted that way. I mean, the current code that we have in place now that, and as Representative here in the front had stated earlier, that in some counties, judges are interpreting the current law to read one way, whereas in other counties, they're interpreting it to read another way. And so there's been some confusion across the state. And so that could be one of those things. And there may be cases out there where an individual may have 3, 4, 5 offenses on their criminal record that they say, you know what, I'm going to go back and I'm going to get my one expungement for this offense and maybe not the others, because those others may be something that would not prohibit them from maybe obtaining employment or doing something in their lives that this one offense might. And had they went back and maybe got that expungement for a different offense and then caught another charge later or somewhere in the mix, it could mess things up for them. So we're hoping that makes it a little bit more clear, but it could be somewhat of a deterrent, like you're saying there.
Okay.
Representative Miller.
Under the original bill, physical impact is not significant. Under the amendment, does that change at all?
I don't anticipate that being the case. No, sir.
Thank you.
Representative Miller, if it did, we wouldn't be here hearing this bill at this time. It would be behind the budget. Leader Lamberth.
Move previous question.
Without objection, we are voting on House Bill 2686. All in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. House Bill 2686 goes on to calendar and rules.
Thank you all.
Item number 5 is House Bill 2244 by Chairman Farmer. We have a motion and a second. Chairman Farmer, you're recognized.
Thank you, Madam Chair, committee members. This bill, and I don't have to adopt the amendment, it's already on, right?
Right, it's traveling.
What this bill does is allows for the city of Sevierville to make an adjustment in their local portion of their tourism fees on top of the TDZ there for a potential investment project coming in. It's supposed to bring about $500,000. It is going to bring $500 million capital investment in on the inset. It's going to build a bunch of ball fields and full service hotels, and at the end of its development, it's going to have about $1 billion investment. So this would allow for the city of Sevierville to vote, the city council to vote to allow to reduce. They have a 5% tourism fee on top of the TDZ there. Right now, the statute says they can't drop below that 5%. This bill will allow for them to adjust that maybe to 2.5% or 3% on their local portion. So we're not messing with any state dollars. This is the portion that stays locally. So that's what this bill does.
You've heard the sponsor's explanation. Are there questions? Question has been called. I see no objection. We are voting on House Bill 2244. All in favor, please signify by saying aye.
Thank you.
Any opposed? The ayes have it, and House Bill 2244 moves on to calendar and rules.
Thank you, Madam Chair, members.
Item number 6 on our calendar is next. That's House Bill 1890 by Chairman Grills. Chairman Grills, we have a motion and a second. You are recognized.
Thank you, Madam Chair. This legislation creates the Tennessee Farmland Preservation Fund to protect one of our state's most vital economic contributors, and that would be agriculture. Currently, Tennessee is ranked 3rd in the nation for land loss to non-agricultural development. And to prevent future loss and to help support our farmers, the Farmland Preservation Fund would allow agricultural landowners to place their land into an agriculture easement by entering into an agreement with the Department of Ag that states that their land will only be used for agriculture and agriculture-related development. In return, the farmers would receive a cash payment for the length at the time that the land is in that easement or that agreement. With that, I stand ready for questions.
All right, questions? I see Chairman Williams.
Thank you, Chair Lay. Thank you, Chairman Grills, for this bill. The premise of the bill I really like. I think it's very important for us. Obviously, being 3rd in this category is not one that we're very proud of. But I do know there are several states that have these programs based upon the discussion with Agriculture Commission staff. And so I'm generally supportive of the bill. My concern with the bill a little bit is that statutorily, we're really not setting firm guidelines as it relates to how long these easements would last. I know that there's maybe an idea that we would leave it up to the department in order to contract with those terms. And typical easement processes, easements you generally last, particularly in this case, in most states, last over a great period of time. My fear is if we start down this path, that we'd end up having the same winners and losers over time because we're having to repurchase easements 10, 15, 20 years from now. But I do think it's very important that we preserve our farmlands going forward. So look forward to working with you there. I think there's a little bit of challenge. I just want to go on the record to say that as it relates to me, but appreciate the bill and the intent. Thank you.
Representative Freeman.
Thank you, Madam Chair. And I'm going to echo some of the concerns of my colleague there. As I read it, I'm kind of surprised that the easements aren't in perpetuity, that we're allowing for short term. There's also the ability for the easements to be bought out. There's not. Okay, then I'll retract that statement. The last question I have is what keeps us from giving an easement or buying an easement from somebody that is a gentleman farmer that has their farmland in the green belt, and they grow a little bit of hay that they sell, and that counts as farmland for tax purposes, and then they really don't farm it.
Chairman Grills.
Thank you, Madam Chair. And over here in the subsection E, you'll see an agriculture easement acquired pursuant to this section must not restrict agriculture as defined, and it references what that land is there in that agriculture easement to do, and that is the normal farming practices that take place on a regular basis throughout Tennessee.
Great. Thank you.
Leader Lamberth.
Thank you. And I just want to thank you for carrying this bill. I mean, you put in the hard work on this. I do hope the committee supports this today. In Sumner County alone, we lost 15,000 acres of farmland over the last 10 years. By the way, the University of Tennessee has done that calculation on every one of your counties, every one of your districts, and you can look that up. And it is just, to me, look, this is $25 million of non-recurring funds. These are not easements in perpetuity, and it's not forever, but it's at least a step in the right direction. It's something to try to save that agriculture, that plow on our state, our state, what we're trying to do here as a state. I mean, that is part of who we are. So it's on the seal. It's part of who we are as Tennesseans, but we're losing it. We're losing it every single day with every single generation. So look, I'm not saying this bill is going to change the entire turn of the tide and we're going to go back to a totally agrarian state, but at least it would save a few farms throughout the state. And I appreciate your efforts on this. So thank you.
Representative Miller.
Thank you, Madam Chair, lady. I support the idea, the concept of, I guess, the $25 million, but this is a one-time non-recurring funds.
Chairman Grills.
Thank you, Madam Chair. That is correct, but will be open for any funds that are not used this year, will be carried over until next year, and then every General Assembly from there on can put more money into it if they see fit.
You're ahead of me. You've answered those questions that I actually had. Another question in reference to the economic impact of our ag industry. What is that economic impact?
Chairman Grills.
Thank you, Madam Chair. I believe the economic impact for the agriculture community in Tennessee is $89 billion. I believe that's correct. I'm not sure right off the top of my head, but that seems to be a number that's close. And I'll tell you this much, that 10% of the agriculture production gross receipts takes place out of my district. So agriculture is king in District 77.
Okay. Thank you, Madam Chair.
Reverend Shaw.
Thank you, Madam Chair. I've supported this in committee, and I support you now. I do think it's a good idea. But someone was talking about the term. I thought, doesn't this say 15-year term?
Chairman Grills.
Madam Chair, thank you. Subsection E4 there at the bottom, at the bottom of my amendment page here, it says, be for a term of not less than 15 years. So it has to be a minimum of 15 years, but it can go longer.
Thank you. I thought so. I just want to clear it up. Thank you.
Representative Barrett.
Thank you, Madam Chair. And sponsor, I concur with the other members that have expressed the desire to address this issue and appreciation for you bringing this bill forward. In concept, I agree with it wholeheartedly. I do have some issues that I've expressed with regards to how vague the statute is in leaving so much open to the promulgation of rules. As a real estate attorney, I read this bill is not so much creating an easement so much as a restriction on the property and how it can be used. And my concern is, how are real estate attorneys and title companies going to be able to deal with this if they come across this in a title search that they are doing on a piece of property that they know that it is not in compliance? So how do we remedy that? What's the enforcement mechanism? There's just a lot of questions that I have that are not addressed in the body of the statute itself or the bill itself. I'd like to see a little bit more clarity on that. But other than that, I'm fully supportive of what you're trying to do.
Chairman Grills.
Thank you, Madam Chair. And Representative Barrett, I understand that you deal with this every day. How do you deal with other easements that you come in contact with? Because that's somewhat foreign to me on how you approach TVA easements and things of that nature.
President Barrett.
Well, thank you for the question. I see this more as a restriction on the property. So for instance, if I were going to create an analogy, I would look at a situation where a property owner or a farmer dedicates a portion of his farm to his church to build a church property on, and says it has to be used as a church. And if it ever is not used as a church anymore, then that family has the right to re-enter and take that property back. This bill is seeking to create a third party interest or restriction that can be enforced by a third party, in this case, the state. So in that scenario, if I came across that property and it was no longer being used as a church, I would have to go back to the family members to get a release of that restriction and have that changed. So in this case, that's the questions I've been asking is what is the process? Who do we go to as a title attorney to get this resolved if we run into a situation? Otherwise, what I fear is we end up creating a lot of situations peppered throughout the state where property gets tied up because of a cloud on the title, and there's no clear-cut process for how to remove that cloud on the title.
Chairman Grills.
Thank you, Madam Chair. And in subsection H, there is a release there that you can, that the Department of Agriculture can enter into with that private property owner if someone passes away and or they become disabled. And I believe in the rules, they would promulgate the rules to encompass those types of issues that you just brought up.
Representative Barrett.
And I guess that's where my consternation is not knowing what those rules are. And I'd feel a lot better if I could see them in the body of the bill instead of waiting for the department to come up with those rules. So thank you, though, sponsor.
Leader Camper.
Thank you, Madam Chair. Representative, I think you may have answered my question. I was concerned about heirs. If I, put the property in this trust and there's a minimum of 15 years going forward, and then I pass away and now my son gets it, will he be able to come out of this trust, or how would that process work?
They're in that subsection. I'm sorry, Madam Chair.
Chairman Grills.
Thank you, ma'am. Subsection H, or in the event that the owner of the land subject to an agriculture easement dies or becomes disabled, the department may release the owner or the owner's heirs from the agriculture easement in a manner established by the department in rule. So they have been charged, the department will be charged to promulgate a rule that will handle the situation such that you just brought up.
Leader Camper.
Thank you, Madam Chair. I understand that, but do you feel, or is it your intent that even in promulgating the rules, if it's less than this 15 years that's required, you wouldn't have a problem with that? Is that your intent? Or what the rules may encompass, if it's 5 years in, sorry, you still got to wait 10 more years, or just, what are you seeing there?
Chairman Grills.
Thank you, ma'am. Well, you wouldn't, if you were in there 5 year or the whole term, you would be out of it. So it would definitely have to be less than what the actual term of the easement would be in. So if you were to pass away halfway through, then you would be, have to work with the Department of Agriculture to be released from the contract that you have entered into with the Department of Ag.
Okay. Thank you, Madam Chair. Thank you, sponsor. That answered my question.
All right. I have no further questioners on my list. Chairman Grills, would you like to have anything else you'd like to say?
Question on the bill.
I'm sorry. Good try, but Chairman Boyd now has a question. Chairman Boyd.
Thank you, Madam Chair Lady, and sponsor. I too like the idea of this bill, and I asked this earlier when the department came by, and I got an answer from him. But I'd like to hear it from you on the record. This is, and you may have covered it. We've been back here talking, but we actually have been discussing this bill. The question that I think a lot of us have is, in certain areas in this state, there is agriculture land, a forestry land that is right on the cusp of some major development. And this would come in very useful for somebody that would like to retain that and keep it in the family and keep farming. But there are other parts of Tennessee where the farmland's not in any, it has no potential to be developed for anything other than farmland. Is the intention of your bill to go to those areas that are being threatened by urban sprawl, rather than it just becoming a farm aid package to people that are not planning to sell anyways?
Chairman Grills.
Thank you, Madam Chair. Absolutely, 100%. That's the goal. Those areas that are pushing for development to turn the family farms into Walmarts and houses and things of that nature, shopping centers. We want to see family farms for eternity. And, I hate to say, I've got a farm. My dad and my mom have always been in our family for 170 years. We don't want to see that ever turned into anything other than cotton, soybeans, and corn. And that's the goal of my family, with that piece of property. I'm sure there's other people here in Middle Tennessee that have urban growth and residential areas everywhere that they love to make sure that their farm could be put in something that would protect it in perpetuity if they so desire to go into that contract with the state.
Thank you, Madam Chair Lady. I'm good.
Leader Camper, I'm sorry, Leader Camper did have a follow-up, and
thank you. Thank you, Madam Chair, and thank you for withdrawing the motion. I did have a follow-up to the question I asked about the heirs. So if you're in this for 15 years and then the heir decides to negotiate and move on, will they have to pay back whatever trust that had been given to them for those 5 years, or how would that part work?
Thank you, Madam
Chairman
Chair.
Grills?
There would be some type of penalty that would have to be in there. I can't see that, I can't imagine there not being some type of penalty, but that would have to be worked out the longer you were in, and the more money you receive from the state because of that. You couldn't just walk away because you did not fulfill your whole obligation.
Representative Love?
My question was answered. Thank you, Madam Chair.
All right, now, without objection, I see no more questions. Last call for questions. Question has been called. We are voting on House Bill 1890. All in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. House Bill 1890 goes to calendar and
much.
rules. Item number 7 is House Bill 1936 by Chairman Haston. We have a motion and a second. Chairman Haston, you're recognized.
Thank you, Madam Chair. It's of course important for us to prepare our students for the next grade level and for the next test they might be taking. But I don't know if there's anything that we do in education that's more important than preparing our students for their first career. This bill would provide our seniors the ability to take a nationally recognized career readiness assessment, which is usually the ACT Work Keys. This assessment can directly connect students to the Tennessee workforce. With that, I'll be glad to answer any questions.
You've heard the chairman's explanation. Are there questions? Seeing none, we are voting on House Bill 1936. All in favor, please signify by saying aye. Any opposed? House Bill 1936 goes to calendar and rules.
Thank you, Madam Chair and Committee.
Item number 8, House Bill 1830. Chairman Littleton. Chairman Littleton, you have a motion and a second, and you are recognized. And I will note for the record that we do have a funding letter for this bill.
Thank you, Madam Chair. This says effective September the 1st, 2024, creates an additional trial court in the 23rd Judicial District.
Are there questions of the sponsor? Seeing none, question has been called. Without objection, we are voting on House Bill 1830. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 1830 goes to calendar and rules.
Thank you, Madam Chair and Committee.
Next on our agenda is item number 9, House Bill 1899. Chairman Rudd, we have a motion and a second, and Chairman Rudd, you are recognized.
Thank you, Madam Chairman. Thank you, committee. This is the SRO Expansion Act that we had passed during special session, and it is back again. What this bill does is it through the let's see, many counties, as many of you know, are finding it very difficult and hard to staff the school resource officers. There's simply not enough deputies, especially in rural areas and some urban areas, to find enough officers to be in these schools. This would expand the SRO Expansion Act, would expand the let the LEAs hire dishonorably discharged veterans and retired police officers. They would have 40 hours of minimal training. With a post commission, they would also only be able to carry a firearm in schools with the permission of the sheriff and the LEA. And they would have to be fingerprinted, undergo background checks by the TBI and FBI, and they would have to be evaluated by a psychologist or a certified mental health professional. And with that, this would help them greatly. Right now, there is no protection at all for our children in schools where they can't find deputies, where they don't have enough to hire. So they're very vulnerable to an assault. And this would give them some protection and help local law enforcement. It would also, by having these minimal training, this would also open them up to be eligible for receiving the state grants for SROs. Right now, they can put security officers and their own people, their own employees in. We have put pretty stringent training and background checks in here. If we go any further, we wouldn't be able to find anyone. And the LEAs, we've left it open enough so that the LEAs can put additional requirements in if they so choose. We don't want to tie their hands too much, and this is permissive, Madam Chairman, and with that, that's the bill.
Thank you, Mr. Chairman, for a very thorough explanation. Are there questions of the sponsor? Chairman Boyd, you recognize.
Thank you, Madam Chair Lady. And sponsor, it sounds like a really good bill and what I'm reading, but me and several veterans on the committee all looked at each other when you said dishonorably discharged veterans. I just want to make sure
Honorably,
you meant
excuse me,
honorably, right?
honorably.
Okay. All right. Thank you, Madam Chair, lady.
I'm glad you corrected that. Thank you.
Chairman Boyd, thank you for being on the ball there. Representative McKenzie, you have a question?
I did, but thank you, Representative Chairman, for bringing that out, because I heard it similarly. So, as we've discussed, I get and understand and appreciate the intent of the bill, but I think streamlining or expediting training to be a school resource officer, which is going to be the only person, I hope, that can possess a weapon who's routinely in the building, that's an awesome responsibility. So to expedite this for some, I have an issue with. I don't have an issue with the retired officers, because they're getting annual training on how to deal with, kind of person-to-person interactions. But a military person, that's a huge span of skills and abilities. They may be a nuclear submarine operator. They may be a cook on a ship. They may be a foot soldier in the Army. That's just, it's our military is a city, and it's also a reflection on us in terms of our jobs and skills and skill sets. So to say, and I'm saying this very carefully, simply or solely because you've been honorably discharged, you now can go into our schools and with, again, a minimum, I think that was your word, a minimum amount of training to expedite that I think is somewhat Pollyanna in terms of thinking that you're going to get a perfect person in all schools. I think those persons need to be, trained fully to be those guardians of our most tender and precious resources, our children. So again, I'll ask, shouldn't we separate those two? And simply because you got an honorable discharge, how does that equate you, regardless of what your job was in the military? Some, I get it. Military police, special ops, all of that I get. But simply because you got, or solely because you got an honorable discharge, regardless of what your job was in the military, how does that equip you to have this expedited path to being a school resource officer?
Chairman Rudd.
Thank you for the question. As we've discussed in the past, we have several problems here that we have in schools right now. Most of this is in rural areas. Some of it's actually in urban areas and in suburban areas. We can't find enough deputies. So if someone had to have the 6 months worth of training, the 160 hours versus the 40 hours, they'd already be deputies. So the fact is, we can't find the personnel to protect our children. The only two other qualified, we're not opening this up to anyone off the street. Of course, retired police officers, not every county has retired police officers. In fact, many police officers, when they retire, they may move to Florida or may move somewhere else where their family is. If we narrow this down to just retired police officers, their field of who we'd have to choose from is very, very limited. We've left this as a permissive act, and they will be employees, unlike the SROs who are employees of the county sheriff's department or the local city police department. These will be employees of the LEA. The LEA is not going to put someone that does not pass a psychological test and doesn't meet their criteria. They may very well need three veterans, and 2 of them are former military police or SEALs or mountain rangers or some other training. Others may not in the school. I'm sure the school is not going to put anybody to guard our children that's not qualified. I don't want to tie their hands and narrow the field so much that there's simply no one left to guard the kids. And that's why we've opened it up to honorably discharged veterans who have trained in weapons. And again, the sheriff will decide whether they can even carry a weapon. And I also remind the members of the committee something else. Right now, at their own expense, schools can, if they have the money, They can go out and hire a security company, an armed security guard to be in their schools at their own choice, and they may not have any police or military background. They can hire any employee they want to be on their own property and to guard their schools, armed or unarmed, without the permission of the local sheriff. So we put a lot of guidelines here. They have to have the permission of the local sheriff to be armed. They have to have 40 hours of post-commission training. They have to have a background check of TBI, and they have to be analyzed by a psychologist or a mental health professional to make sure they're fit to be in the school and qualify for state funds. So I think that we have put a lot of restrictions on here, but left it open enough for the LEA to make their own decision and put additional requirements in at the local level.
Representative Parkinson. Representative Shaw.
Thank you, Madam Chair, and thank you, Mr. Sponsor. Every once in a while, I guess something come along where you just get a gut feeling it's not a good idea. So I'm just going to say to you, I appreciate you bringing legislation, but I just got a gut feeling it's something don't feel good about it. And I'm going to want to be recorded as a no vote.
Are there any other questioners? Chairman Keesling.
Thank you, Madam Chair. Sponsor, thank you. We need this. We need this in rural Tennessee, that's for sure. We need it across my district. It's tough to recruit, to find people with any even small amount of background. And I totally trust the LEAs that we've got across our district that's going to make the right decisions, the hiring decisions. And again, I urge the members of this committee to support this legislation. Thank you, Mr. Chairman. Thank you, Madam Chair.
Other questions or comments? Seeing none, we are voting on House Bill 1899. All in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. If you'd like to be recorded as a no, then please let the clerk know.
Thank you, Chairman. Thank you, committee.
That brings us to item 10, which is House Bill 2190 by Representative Fritz. We have a motion and a second. We do have an amendment on this bill, drafting code 016189 is what I show. Representative Fritz, does that match what you have?
Thank you, Madam Chair. Yes, ma'am, 16189.
We have a motion and a second. So without objection, we are voting on drafting code 016189 being added to House Bill 2190. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. The House Bill 2190 is so amended. And Representative Fritz, if you would please explain your bill as amended.
Thank you, Madam Chair and committee. This bill very simply gets us in compliance with Article 3, Section 5 of our Tennessee Constitution so that we are approving deployment of force in support of an invasion. The changes that you see in this bill, the reason it's no longer behind the budget, as you know, had a fiscal note on it. We modified the bill to remove the recurring special session type activity that could be required in this and just made it a one-year bill. It stands as that now, and there's a letter from Mr. Bryson offering funding to the $1.4 million. And with that, I would stand and take any questions, ma'am.
Representative Freeman, you're recognized. Question has been called. Without objection, seeing none, we are voting on House Bill 2190. All in favor, House Bill 2190 as amended. All in favor, please signify by saying aye. Aye. Any opposed? Please let the clerk know if you'd like to be recorded as a no, but the ayes do have it, and the bill goes on to calendar and rules.
Thank you, Madam Chair and committee.
Item number 11 is House Bill 2264 by Representative Hakeem, who's been patiently waiting. Representative, you have a motion and a second. You're recognized.
Thank you very much, Madam Chairman, members. The bill authorizes schools with interventions to be able to exit Department of Education turnaround programs, but it requires that all debts that have been incurred to be paid, and that the school would notify the desire to exit a turnaround program. This has been done in consultation with Senator Watson and with the superintendent of Hamilton County Schools. And with that,
All right, the question has been called on the bill. I see no objection, so we are voting on House Bill 2264. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 2264 goes on to calendar and rules.
thank you very much, Madam Chairman and members.
Next is item 12, House Bill 2613 by Representative McCollum. Representative, you are recognized, and I show that we do have an amendment on this bill.
Yes, Madam Chair, we do. It is drafting code 017846.
That's what I have. Do I have a motion on the amendment? I have a motion and a second on the amendment. Without objection, we are voting on the amendment, drafting code 017846 being added to House Bill 2613. All in favor, please signify by saying aye. Any opposed? The ayes have it. If you'd like to be recorded as a no, then please see the clerk. We are now on the House bill as amended. Representative McCallum, if you would please explain your bill.
Thank you, Madam Chair and members. What this bill, House Bill 2613, does, it creates a new, more restrictive liquor by the drink license for applicable only for barbershops, cosmetology salons, and cigar bars. It decreases the number of seats from 40 to 20, but it also decreases the hours that these establishments can sell alcohol from 3 a.m. to 10 p.m. It puts a cap of 15% of total revenue on these establishments. So no more than 15% of their total revenue can come from alcohol sales. This was brought to me by a constituent, and I'm hoping that y'all will give it a favorable vote. And I stand ready for questions if there are any.
And I do have some questioners on my list. Representative Freeman, you're recognized.
Thank you, Madam Chair. And quick question for you. The way I read it is it deletes subsection 4 of the current code that allows for the distribution or serving of alcoholic beverages at like a nail salon. So if somebody goes into a nail salon to get their nails done, they get a glass of wine or a beer. Can that still be given as a freebie under your legislation?
Representative McCallum.
Thank you, Madam Chair. Representative Freeman, in a prior iteration, we inadvertently removed that from the bill. This amendment that we just put on replaced that. So yes, the cosmetology salons and barbershops, if they still want to be able to give it away for free, they have that ability. They have the ability to do this. What this does is just provide an avenue if they want to sell this to customers.
Representative Freeman.
Thank you, Madam Chair, and thank you, sponsor. My wife and several of her friends asked me to make sure that that was not removed from the legislation. So appreciate you clarifying that.
I would note that probably it's not free. It's just included in the price. Representative Parkinson.
I was going to call a question, Madam Chair, but if I don't want to step on anyone if anyone had any questions.
Thank you for that, Representative Parkinson. We do have a couple other questions on our list. Representative McKenzie, you're next.
Thank you, Mr. Chair. Thank you, Madam Chair, and thank you for bringing this bill. I think, as we kind of evolve, that this is it's a neat thing to do. It's going to be something that some people will take advantage of statewide. So thank you for bringing that. So that kind of gets to my question. If a business doesn't want this type of restricted license, they're not forced into this. They can still use the existing laws to get their businesses, right?
Representative McCallum.
Thank you, Madam Chair. Yes, Representative McKenzie, they can still go through the full liquor by the drink license that does not have the restrictions. This just provides I guess, a niche market for these particular type of industries.
Thank you, and thank you for bringing the bill.
Leader Cochran.
Thank you, Chair Lady. Sorry for the delay. Hey, so one quick question, Representative. So you mentioned that it was reducing operating hours, reducing the number of seats. So just to clarify, these businesses can do this now. The barbershops, cosmetologists can serve alcohol now, or this is a new thing? Can you clarify that for me?
Representative McCowan.
Thank you, Madam Chair. Yes, Leader Cochran, they can, but they can't charge for it. Where this came from is a constituent who owns a barber shop in Franklin. He has a full liquor by the drink license. He says this is a round peg in a square hole. By law, I could give it away, but if I want to recoup my costs from what I'm having to purchase, I have to have a full liquor by the drink license. He says I'm not trying to be a full bar. He says really this is just so to add to the experience. You come in, you get a good haircut, and you get to purchase a cocktail after you're done. So yes, current law, they can give it away right now, but they can't charge for it unless they get a full liquor by the drink license, which can be very cost prohibitive on some of these smaller businesses. So this provides a less expensive but more restrictive medium for which they can sell cocktails.
Leader Cochran.
Thank you. And just one quick follow-up. So for instance, like item C, where it says has no more than 20 seats for food service for patrons. I think you'd mentioned you were this was reducing from 40 to 20, but you're saying currently if I wanted a liquor by the drink license, that says 40, this is reducing it to 20 to better fit the needs of the barbers and cosmetologists.
Representative McCowan.
Thank you, Madam Chair. Yes, sir, Mr. Leader, that is correct.
All right, thank you.
Yes, sir.
Chairman Hawk.
Thank you, Madam Chair. And I probably won't say this on the floor, but as one might imagine, it's been a long time since I've been to a barber shop. The business models that have changed and evolved in our establishments like this are quite interesting. And I have constituents in my district who have specifically asked for this legislation to move forward as well. So I'm happy to co-sponsor with you, Representative McCowan. Thank you, Madam Chair.
Leader Lamberth.
Move previous question.
Previous question has been called. Without objection, we are voting on House Bill 2613. All in favor, please signify by saying aye.
Aye.
Any opposed? No. Please let the clerk know, but the ayes do have it, and House Bill 2613 moves on to calendar and rules.
Thank you, Madam Chair and committee.
Item 13 on our calendar is House Bill 2261 by Representative Wright. You have a motion and a second. Representative Wright, you're recognized.
Thank you, Madam Chair and committee. This is House Bill 2261. Defines a home for the age that houses 3 or fewer unrelated persons that is subject to licensure and regulations by the department. This housing could be happening right now, but only found out about it by report of neglect. This sets up a program to go check, helps provide relatively permanent domiciliary care. And with that brief explanation, I stand for questions.
You've heard the sponsor's explanation. Anyone requiring additional details? Seeing none. Without objection, we're voting on House Bill 2261. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 2261 goes to calendar and rules. Thank you, Representative Wright.
Thank you, Madam Chair and committee.
Next on our agenda, item 14 has been taken off notice at the request of the sponsor. That brings us to item 15, House Bill 2088. Do I have a motion? Motion and a second. Chairman Whitson, you're recognized.
Thank you, Madam Chairman. Request to do it from my desk. And members, this legislation creates a mechanism for the Tennessee Military Department to enlist and retain skilled members in critical specialties in our highly competitive job market. For example, our military department is currently experiencing a shortfall, a water purification specialist and air traffic control equipment repair specialist. The department board will look across the formation and identify those critical skills that left unfilled pose a risk to the department's ability to respond to domestic or federal missions. The board would then recommend to the Adjutant General an enlistment or retention incentive up to $10,000 for the shortage or unfilled military jobs. The board will convene throughout the year to reassess and ensure these funds meet the needs to fill these critical job specialists. The next part, this bill will replace in code what has been done for the past 23 years by executive orders. With this legislation, if a state employee is also a member of a reserve component of the armed forces and they are called to active duty by the federal government for a contingency operation and their military pay pays less than their state job, the state will pay the difference in wages so the employee does not suffer a financial disadvantage. Intent is not to disincentivize our state employees from serving as members due to any possible financial hardship. And with that, Madam Chairman, I renew my motion.
Thank you, Chairman Whitson. Leader Lamberth.
Thank you, Madam Chairman. And if this bill were to be successful, Chairman, would it be the last bill that you present on the House floor?
Chairman Whitson.
Thank you, Leader Lambert. That's really up to the chair lady and the chairman of the finance subcommittee. I have 2 bills behind the budget. I hope not.
Leader Lambert.
Hope springs eternal. But I will say, Chairman, thank you for presenting this bill. Thank you for bringing this. You've given a lifetime of service to our country. Thank you for your service in that regard and your service to the state. I know you'll be retiring and leaving us, but I, for one, just wanted to say publicly thank you. I wish you the best in having bills before this committee beyond this one, but thank you for presenting this one. It is a very good bill, and it is one that is right up your alley, so we appreciate you carrying it. Thank you.
Chairman Whitson.
And Leader, I can assure you, my military special would never get a retention bonus. Okay, thank you.
Thank you. I just want to take this opportunity to say I know we'll have other opportunities to wish Sam well in future endeavors, but Sam and I have grown to be very good friends over the course of our service here together, and I think that's one of the major benefits of serving in this role. I would not have met Sam Whitson if we had not both been here serving in the legislature. So I'm grateful for that. I'm grateful for the work that he has done both in his Army career and in his legislative career, but most of all, I'm grateful for his friendship, and I'm going to miss you, buddy. But without objection, we need to get Chairman Whitson's bill on to the next step, and we are voting on House Bill 2088. All in favor, please signify by saying aye. Any opposed? The ayes have it, and House Bill 2088 goes on to calendar and rules. That does complete our calendar for today. Do we have any further business coming before the committee? Seeing none, we stand adjourned.